Court's going to deny the application. There's punishment is to be assessed at a cap of 7 years. The court is finding you guilty. Would parties like to speak to the cap?
American Justice Vault.
Just a moment. Court is calling 2021 CR 0392, State of Texas versus Adam Isaac Gonzalez. Can I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
Monica Guerrero for Mr. Adam Gonzalez, and he's present as well. We're ready.
All right. And are you Mr. Gonzalez? All right, you entered a plea on March 28th of no contest. The state waived the enhancement without objection. You applied for deferred adjudication. According to the plea bargaining agreement, punishments to be assessed at a cap of 7 years in the prison. There's an affirmative finding of deadly weapon. The state is opposed to your application for deferred adjudication. And there's restitution and no contact orders as a part of your agreement. Have both parties had a chance to review the PSI report state?
Yes, Judge.
Defense?
Yes, Your Honor.
Any objections to the PSI report state?
None.
Defense?
No, Your Honor.
All right, state, do you have any witnesses?
No, Judge. Just argument.
Defense, any witnesses?
No, Your Honor, just argument.
All right, then state you're opposed.
Yes, Judge. We would be opposed to his application for deferred, Judge. As you're well aware, you've read the steps in this particular case, Judge. This is a small food mart in an area of town that they provide services to the public there. Mr. Gonzalez took it upon himself to go in there with a handgun to a place that he lives right next to and place the person who worked there, who was working for a living, under fear while he stole approximately $3,000 from him. Judge, the store clerk identified Mr. Gonzalez because he recognizes him and his brother from the neighborhood, and Mr. Gonzalez was found nearby. He has criminal history dating back to the mid-1990s. He has a gang affiliation. I think in this case, Judge, he deserves to go to prison. I don't think that deferred adjudication would be appropriate in this case. He takes no responsibility for what happened that day. He takes no responsibility for any drug issues he has. We believe it's a prison case that he deserves to go to prison on.
All right, defense.
On behalf of my client, Judge, if the court will note in the PSI that his last any type of criminal activity or any type of intervention hasn't been a part of his life since the latest was 2008, and that was a misdemeanor, and 1994 for felonies when he was super young, and was revoked, which would be now state jail felonies, to 10 years in prison. He's tried to maintain sobriety. He hasn't used drugs in a long time. He hasn't had any drinks. And he's trying to help his mother, who is now elderly. He has a child that's 6 years old. He hasn't been able to work regularly because he's on full GPS. So he hasn't been able to get money to pay his child support, which he's in arrears for. He would like the opportunity to show the court that he can complete deferred adjudication, that his life has changed since the 90s. And his mom needs him. She would have been here, but she has disabilities and she's working at a pinata shop. So she couldn't just leave to come here. She does want him home. He hasn't had any violations while he's been on GPS, and it's been nearly 2 years. So we're asking that the court gives him a chance to be on this deferred adjudication, Judge.
All right, is there anything you wish to say, Mr. Gonzalez?
Well, ma'am.
Court's going to deny the application. There's punishment is to be assessed at a cap of 7 years. The court is finding you guilty. Would parties like to speak to the cap?
Yes, Your Honor. Well, I guess the state gets to go first.
We believe 7 is appropriate, Judge. His conduct is escalating. This is the most serious offense he has. We believe 7 years is appropriate. He was facing up to life in prison on this case. The plea agreement already reduced his exposure all the way down to 7. We believe 7 is appropriate.
Right.
And Judge, we're asking for the minimum. This was a case that he felt was very tribal, and he's indicated to me that it may be somebody else in the family that was not him. However, we understood that he was going to come in and accept responsibility, and we're asking for the minimum.
All right, the court is going to follow your agreement and sentence you to 7 years in the prison. There's an affirmative finding of deadly weapon. Does anyone want to speak to restitution? I have a restitution amount in here of $3,000. That's what was agreed to. So restitution of $3,000 to La Tienda, Tienda Food Mart. No contact with Tharun, Tharun, Kandada, Kandada, or La Tienda Food Mart at 627 Couples. I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you electronically sign it? Yes, did you review that document with your attorney? Did you understand it? And did you electronically sign it? It's a trial court certification of defendant's rights to appeal. Your signature is here.
Yeah.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what the definition of a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Mhm.
All right. Yes.
Is there any way that I can just take it to trial?
All right, Mr. Gonzalez,
Yes, ma'am.
you entered into a plea bargain agreement, and according to that plea bargain agreement, your punishment was to be assessed at cap of 7 years. I followed your plea bargain agreement. So you're going to prison for 7 years. You've been found guilty. You're given credit for any time served. Do you understand?
Right.
All right, good luck to you.
And just like that, it was over. 7 years, one decision, no going back. What makes this case unforgettable isn't just the sentence, it's the moment right after, when reality finally hit and the defendant asked the question that came too late, can I take it to trial? But in the courtroom, timing is everything, and once a plea is entered, the door closes. This wasn't just about one mistake. The judge made it clear this was a pattern, a path that kept getting worse. And when a deadly weapon is involved, the system doesn't take chances. Even with a deal on the table, even with a reduced sentence, the outcome can still hit hard. Think about it, facing life in prison, then getting a second chance with a cap of 7 years, and still walking away with the maximum. It shows how serious the situation really was. No shouting, no drama, just a quiet courtroom and a life changing in seconds. That's the reality of cases like this. Every choice matters. Every signature on a plea deal matters, because once the judge speaks, that decision is final. And in this case, by the time he realized what it truly meant, it was already too late.